Good evening, class. Tonight's lesson will be Title 7 of the Revised Corporation Code of the Philippines. We will be talking about stocks and stockholders. So for this lecture, the source materials are the book Partnerships and Private Corporations by De Leon and De Leon Jr. as is applicable, and also the book Revised Corporation Code of the Philippines, a short introduction by Aquino and Aquino. So let's begin with the definition of a subscription contract. So ang subscription contract is the contract that will be entered into by a subscriber and also a corporation or corporation still to be formed for the sale of shares. So pagka bumibili ka ng shares, you will enter into a subscription contract with the corporation or with a corporation still to be formed. So a subscription contract is defined under Section 59 as the contract for acquisition of an issued stock in an existing corporation or a corporation still to be formed. So remember, if the parties refer to it as a purchase or some other contract, it is still considered a subscription contract under Section 59. So remember also that participation is in a corporation is acquired in the following ways. In case of a stock corporation, paano ka ba magiging stockholder? You subscribe to unissued shares. So there is a subscription contract and you buy unissued shares. What else? Number 2, you can also purchase treasury shares from the corporation. So remember, obviously, yung treasury shares nyo are shares reacquired by the corporation and nilagay sila sa treasury. What else? Also, to become a stockholder, you can buy outstanding shares from other stockholders. So transfer from previous stockholders. What else? In a non-stock corporation, what you have to remember is that membership is acquired by contract and the modes of entering into which will vary according to the charter and bylaws of the particular non-stock corporation. So it depends on the qualifications set by the non-stock corporation. It depends on the rules set by the non-stock corporation. Please take note also of yung trust fund doctrine, which we have already studied in Title 4 of the Revised Corporation Code of the Philippines. The trust fund doctrine again states that stock subscriptions are in the nature of a trust fund and they are to be maintained unimpaired for the protection of corporate creditors. So yung stock subscriptions, remember, ipambabayad yan sa corporate creditors. What else? Please take note also of the kinds of subscription according to Section 60. So there are two kinds, yung pre-incorporation subscription and also yung post-incorporation subscription. So yung pre-incorporation subscription defined under Section 60 as one entered into before incorporation, and it will constitute also a binding contract among the subscribers. So what you have to remember about pre-incorporation subscription is that it is mandatory. Before mag-incorporate ang corporation, it is mandatory. Kailangan nilang magbenta ng shares. Kailangan nilang maghanap ng subscribers, etc. etc. So kailangan din nilang maghanap ng incorporators. But remember class, ang mga subscribers, mga incorporators, lahat yan may shares of stock. So in short, kailangan nilang magbenta ng shares before a corporation is incorporated. In the old law class, remember, kailangan pa nga ang pre-incorporation subscription is 25% of the capital stock in case of no par value shares and 25% of the authorized capital stock in case of par value shares. But now, dinilit na nila yung provision na yon. So, any portion of the authorized capital stock or the capital stock must be subscribed. Pero kailangan talaga may subscription, hindi pwedeng wala. So this is, remember, mandatory. In case of post-incorporation subscription, this is entered into after incorporation for the acquisition of an issued stock. So remember class, yung subscriber will become a stockholder, sinabi ko na ito before, upon acceptance of the corporation of the subscriber's offer, or kung yung subscriber naman yung corporation naman ang nag-offer, upon acceptance of the subscriber of the corporation's offer, even though the shares have not been paid yet. So also, please take note of the rules regarding pre-incorporation subscription contracts. It is, remember, irrevocable in 2 cases. Number 1, it is irrevocable for a period of at least 6 months from the date of subscription in case of corporations still to be formed, notwithstanding any agreement to the contrary. Sabi ng law na ang nagsabi, at least 6 months. So it cannot be for a lesser period, even if that is the agreed upon period, dahil ito ay provide ng law. It is irrevocable for a period of at least 6 months. What else? No pre-incorporation subscription may be revoked after the submission of the articles to the SEC, even though it is beyond the 6 months period. So, if it is beyond yung 6-month period, nagkataon, hindi mo pa nababawi yung iyong subscription. Hindi mo na siya mababawi kung na-file na yung articles of incorporation sa SEC. But, of course, these rules are subject to exceptions. So, the exceptions are, number 1, if all the other subscribers consent to the revocation, even if, and number 2, the incorporation of the said corporation fails to materialize within the period, said period of 6 months or within a longer period as may be stipulated in the contract of subscription. So remember, at least 6 months. So if in 6 months time, the corporation does not incorporate, pwede nang i-revoke yung subscription. If in the subscription contract, ang sinabi irrevocable for a period of 1 year, that is a longer period but it is provided for in the subscription contract. Ngayon, pagka lumipas na yung 1 year na yan, hindi pa rin na incorporate itong corporation na to, the subscription will become revocable. So also please take note that the reason why subscription contracts are generally irrevocable is para ma-prevent yung speculation with respect to stocks on the proposed corporation. And also, maganda rin na kung may subscribers ka, may operating capital yung corporation. Yung operating capital niya will come from the subscriptions. Kaya, para ma-protect ang corporation from irresponsible subscribers, bawal i-revoke yung kanilang shares for yung kanilang subscription for a period of at least 6 months. Yan. Also, please take note of the consideration for stocks. Anong ibig sabihin ng consideration for stocks? Ito yung pwede mong ibayad sa shares of stock. Now, before we proceed with the items or mga modes na pwede mong ipambayad sa isang share of stock, you must also remember the sources of corporate capital. Saan ba nanggagaling ang pera ng corporation? Common sense, of course, from number 1, subscription. So, funds furnished by the shareholders. So, contributions ng shareholders or yung mga money received by it for the issuance of shares of stock. Also, another source of corporate capital is yung borrowings. So, pwedeng manghiram ang corporation from creditors. And itong mga borrowings na to will become part of the corporate capital. Yan. Para nga naman, mangungutang sila para meron silang operating capital. What else? Also, another source of corporate fund is yung profits and stock dividends. So, obviously, yung profits of the business can be reinvested in the business. How does a corporation reinvest its profits to the business? Usually, they issue stock dividend. Yan. Because again, as we have already studied in Title 4, yung mga stock dividends, when they are issued, it is a forced sale of shares of stock. And remember, yung mga issuance of stock dividends is transfer from surplus to the capital. So, yun ang tandaan natin. Pinipilit natin na mag-reinvest yung mga stockholders sa corporation if we issue stock dividends. What else? Also, please take note of the different modes by which shares may be issued. So, by subscription, before or and after incorporation to unissued original stock. Also, sale of treasury shares after incorporation. What else? Subscription to new issues of stock. Pagka naubos na lahat ang original unissued shares, pwedeng mag-increase ng capital stock ang corporation and pwede kang mag-subscribe doon. So, yun ay isa na namang mode ng issuance ng shares. And also, by declaring stock dividends. What else? Consideration for issue of stock. Ito yung mga pwede nating ibayad for shares. Obviously, number 1, cash paid to the corporation. Property, tangible or intangible, which are already received by the corporation. And provided class that there is a fair valuation of the property and the valuation is equal to the par or issued value of the stock issued. So, kung magkano yung subscription mo, dapat ganun din yung value ng property na ibibigay mo sa corporation. Property, again, may be tangible or intangible. Labor already performed or services already rendered to the corporation. Dapat tapos na. Labor is already performed, service is already rendered to the corporation. What else? Previously incurred indebtedness of the corporation. So may utang ang corporation sa creditor. They will issue shares. Instead of paying for the debt, they will issue shares to the creditor and the creditor will become a stockholder. So, ang pinambayad ng creditor na ito is actually yung previously incurred indebtedness of the corporation. What else? Add to that, amount transferred from URE to stated capital. So, again, ito yung surplus profit. Ito yung profit URE, which will be transferred to capital. How? Again, by the issuance of stock dividends. What else? Number 6, outstanding shares exchanged for stocks in the event of reclassification or conversion, and shares of stock in another corporation. Lastly, other generally accepted form of consideration. So, itong mga to ang pwedeng ipambayad sa shares of stock in a corporation. Take note also, class, of the limitations when it comes to considerations for stocks. So remember, number 1, shares of stock and bonds may be issued in exchange for any combination or any 2 or more of the considerations enumerated in section 61. So remember, you can pay using cash and property and stocks, etc., etc. You can combine the modes of payment. What else? The corporation may receive more than the par or issued value. Obviously, class, pagka shares of stock, usually naman, if it is from corporation to a stockholder, hindi naman binebenta yan sa par at issue or issued value. So, it is usually more than par, more than issued. And remember, for no par value shares, pagka nagbayad ka ng more than issued value, remember, the entire subscription or the entire payment will become part of the capital of the corporation. Now, in case of payment of par value shares at more than par, remember, magkakaroon kayo ng share premium. So, what else? Shares of stock shall not be issued for a consideration less than the par or issued price thereof, except in cases of treasury shares. So, also remember here that considerations in cash and property may be subjected to several rules. In case of cash and property, payment must be actually received by the corporation. How about negotiable instruments? So, negotiable instruments such as promissory notes, checks, pwede naman silang pambayad, but they will produce only, payment only when they have been cashed, or through the fault of the creditor, the negotiable instruments have been impaired. Also, if it is property, which may be tangible or intangible, as I have said a while ago, it must be subject to a fair valuation, which is equal to the par or issued value of the subscription. Now, the valuation is initially determined by the stockholders or the board of directors, but it is always subject to approval by the SEC. So, either way, if the valuation is made either at the time of incorporation or thereafter, it should be subject to approval of the SEC. So, laging pinapa-approve ang valuation ng property. What else? Shares cannot be issued in exchange for promissory notes. So, halimbawa, meron akong promissory note, tapos, obviously, if I'm a holder of a promissory note, I'm a creditor. So, meron may utang sa akin. So, ang pambabayad ko yung promissory note. As a general rule, remember, that cannot be used as consideration for shares. But, this, as cash payment, hindi pwede. Because hindi pa naman siya natatanggap it's still only a promissory note. But remember, class, this may be considered as property payment, but always subject to verification by the SEC of the existence of the debt and also collectibility of the debt. And also, remember, in this case, yung shares will be held in escrow until actual payment of the amount. So, pwede namang ipambayad ang promissory note but subject to rules. It is property payment, and also SEC must verify yung existence and collectibility of the debt, and they will be held in escrow. Yan. Financial instruments such as notes, yun nga, shares of stock, and bonds may be classified as personal property. What else? US dollars representing payment on subscription should be converted to Philippine peso to be treated as cash. Now, kung dollars, they are considered as property payment. What else? If the consideration is other than cash and property, these are some of the rules. If the consideration is other than actual cash, its value must be worth the value of the stock subscription. So again, there must be approval by the SEC of approval of the valuation by the SEC. Also, a corporation is allowed to receive not only money and property, but also labor and services already performed or actually rendered to the corporation, provided that the transaction is in good faith and there is no fraud. What else? Yung compensation payable for services actually rendered to the corporation is, again, credit, and the value is ascertainable. Yan. So, kung halimbawa the service is to be rendered pa lang, it is not an acceptable mode of payment. What else? I think that's it. Yes, also please take note that a corporation cannot issue stock as a gratuity, but it is lawful for a corporation to issue bonus stock to officers or employees as incentive for services actually rendered to the corporation. So, because there are already services rendered to the corporation, it is cannot be considered as gratuitous transfer. So, what else? In case of stock subscriptions of corporations, so ang corporation ay bumili ng stocks sa ibang corporation. So, remember, pwede na yun ngayon, even noon pala. But now, even domestic corporations can become incorporators. Before, mere stockholders lang sila. But at any rate, in both cases, they are owners of shares of stock. But remember here, it is the policy of the SEC to require corporations to pay their subscriptions in full. Bakit? Because remember, corporation has an unlimited capacity to contract obligations, but it has only limited capacity to pay. That is why the SEC will require full payment of subscription in case of corporations buying stocks in another corporation. Also, how about the fixing of issued price of no par value shares? Remember, these are the rules. The three modes of fixing the issued price is, number one, if it is fixed in the Articles of Incorporation or any amendment thereto. It may also be fixed by majority vote of the OCS in a meeting called for that purpose. What else? The issued value of shares, no par value shares, may also be fixed by the board of directors pursuant to authority conferred by it by the articles or the bylaws. Remember also that changes in value of issued shares, hindi pwede ito. If no par value shares na ibenta na sa stockholders yan, hindi na pwedeng palitan ang kanyang issued value. Because remember class, shares of capital stock issued without par value shall be deemed fully paid and non-assessable. So, bayad na yan. Paano mo pang papalitan ang issued value? What else? Please take note also that in case of change in the value of unissued shares, pwede yan. Kasi the shares are unissued. So, remember, in case of no par value shares, pwede mong palitan ang kanyang issued value. Yan. Change in issued value of no par value shares shall apply only to the issued portion of the capital stock of a corporation. How about certificates of stock? So, remember, a certificate of stock is a written instrument signed by the proper officer of a corporation, acknowledging that a person named therein is the owner of a designated number of shares of the corporation's stock. So remember, it will indicate the name of the holder, the number, kind, and class of shares represented, and also the date of issuance. So remember, a certificate of stock is merely evidence of the holder's interest and status in the corporation. But remember, yung kanyang yung ownership niya is also represented thereby. But in the law, yung certificate of stock is not equivalent to ownership. Yan. So, yan pala. Nandiyan pala siya. What else? Number 2 pala. It expresses the contract between the corporation and the stockholder, but it is not essential to make one a stockholder in a corporation or to exercise the rights of a stockholder, especially if hindi pa naman na-issue yung certificate of stock. Because remember, as you will know later on, yung certificates of stock will be issued only upon full payment. And anyway, stock ownership may be shown in the corporate books such as the stock and transfer book. Pwede namang makita yung ownership mo doon, not only in the certificate of stock, but also in the corporate books. So anyway, the right to issuance of certificate of stock, as I have already mentioned, certificate of stock is not necessary to make one a stockholder because kasi nga ang subscription ang necessary to make one a stockholder. Now also remember, if there is already full payment of the subscription and the stockholder or the subscriber has already complied with all the conditions, in case of the subscription, he will have the right to have the certificate of stock issued to his name. So only stock corporations obviously can issue stock certificates. So the requisites to issue stock certificates. So number 1, it must be signed by the president, VP of the corporation, countersigned by secretary, corporate or assistant secretary, and sealed with the seal of the corporation. The par value of par value shares, kailangan nakalagay dyan, or the full subscription as to no par value shares must be fully paid. Certificate of stock is delivered to the stockholder. So also in case of transfer between stockholder and stockholder into a third person who is the buyer of the share, so later on will become also a stockholder, the certificate of stock must be endorsed and delivered to the transferee. So what else? In case of transferee from a stockholder, original certificate must be surrendered. So stockholder ako, binenta ko yung shares ko, dapat i-surrender din yung original certificates of stock ko sa corporation so that they can cancel it. I-record nila yung sale and i-record nila yung transfer to the buyer or my transferee. What else? The transfer must again be recorded in the books of the corporation. It must show the names of the parties, yung buyer and seller, date of the transfer, number of certificates, and also the number of shares transferred to be valid as against third persons, and also the corporation. Kung hindi recorded ang transfer sa book ng corporation, the corporation is not bound, subject to exceptions, and also third persons are not bound, or the transfer is not valid as against third persons. Also, remember that shares of stock can only be transferred by the registered owner or an authorized person by endorsement and delivery. So remember also, class, that this right is inherent as an incident of ownership. So because a stockholder is the owner of shares, meron siyang inherent right to transfer yung shares na yon. So remember here, as is indicated, absolute and inherent right and as an incident of his ownership to sell and transfer the same at will. So remember, class, pwede namang mag-impose ng restrictions, but it should be reasonable restrictions, and the same are indicated in the articles of incorporation or by a valid bylaw or a valid agreement or valid subscription contract between him and the corporation. So again, to be binding on the corporation, the transfer must be registered in the books of the corporation. Also, take note that in case of legal limitation, ito lang yung pagkakataon na pwedeng i-hold yung transfer ng share is when the corporation holds any unpaid claim against the shares intended to be transferred. So, bawal mag-create ng restrictions ng sa stock transfer unless there is a provision in the law or in the articles which will create such an impediment. But again, in all cases, it must be reasonable. However, if there are unpaid claims against the shares intended to be transferred, pwede yun. Pwedeng i-restrict ang transfer. So, what else? Also, take note on the restrictions on transfer of stock. Kakasabi ko pa lang, pwedeng i-restrict ang transfer ng stock. So, remember, the authority to determine in the bylaws the manner of issuing certificates of stock is granted by law to the corporation. But again, dapat yung mga restrictions imposed are not unreasonable. So, ang pwede lang is to adopt regulations as to formalities and procedures to be followed in effecting transfer. Also, yung imposition of restrictions on the transfer of shares cannot be exercised unless there is, again, a provision in the law, in the articles, or in the bylaws, or even in the certificate of stock to bind third persons. If the transfer is subject to approval of the stockholders or the board or the president, bawal yon, illegal. There is undue limitation on the right of ownership, and it is also a restraint in trade. So, what else? For the same reason, if the condition appearing on the certificate of stock is non-transferable, this is not valid. In case where there is a right of first refusal given to the corporation or to the existing stockholders, pwede ito. So, yung right of first refusal, the stockholder must first offer to the corporation and to the other stockholders yung kanyang shares before offering them to the public. So, this is a reasonable restriction. Usually, this applies to closed corporations. Meron talaga silang mga ganyang klaseng restrictions before shares of stock are offered to the public. Kailangan mo nang i-offer mo sa stockholder. Kasi remember, in a closed corporation, 20 lang sila. That is the maximum. Ngayon, hindi nila pwedeng basta-bastang i-transfer yung shares nila because there are qualifications to be in a closed corporation. That's why offer first to the corporation and let the corporation refuse first before selling it to the public. Kaya nga, right of first refusal siya. Let the corporation refuse first. Let the other existing stockholders refuse first before the same is offered to the public. So anyway, this restriction must appear in the articles, in the bylaws, as well as in the certificates of stock. Paulit-ulit ko nang sinasabi yun kanina pa. So it is allowed obviously in closed corporations, and surprisingly, this is also legally permitted in open corporation as long as it is stated in the articles of incorporation. And yung stockholder who purchases stock in the open corporation is aware of such restriction. Usually the period is 1 month sufficient for the stockholders or the corporations to signify their desire to buy the shares of stock being offered by the stockholder. Yan. What else? Also, please take note, allowed din ang restrictions in case a certain percentage of Filipino office ownership is prescribed. So, if yung transfer will increase yung foreign ownership sa corporation and this is against yung existing laws, pwede nilang i-restrict yung transfer ng shares. Modes of stock transfer, there are actually several. Number 1, there must be endorsement and delivery of the certificate of stock. So, ang pwedeng mag-endorse ay yung and deliver are yung owner or his attorney in fact or other person legally authorized to make the transfer. Yan. So, remember class, the certificate must be properly endorsed and that the title to such certificate of stock is vested in the transferee by the delivery of the duly endorsed certificate. So, even if there is no deed of sale, deed of assignment, basta properly endorsed yung certificate of stock and it is delivered to the transferee, it will constitute a valid transfer of stock. And remember, this transfer is valid as between the transferor and the transferee. However, class, the corporation is not bound to record in its book a transfer of stock and to issue new certificates unless the original certificate is surrendered to them for cancellation or it is clearly shown to have been lost, stolen, or destroyed. Now, if the transfer again is not recorded in the books of the corporation, it is not valid as to third persons and probably also the corporation, subject to exceptions. Because remember, if the corporation is aware of the sale, like there is an intent to transfer the same, kumbaga parang nalaman na ng corporation na there is actually a transfer of the shares, it can bind the corporation also. Now, usually, remember, yung endorsement is done by signing yung certificate of stock on the back. So, pipirma yung stockholder sa likod, tapos i-deliver niya sa kanyang transferee. So, parang ano din to, it is like a negotiable instrument. But remember, certificate of stock does not conform to the definition of a negotiable instrument under the negotiable instruments law. So, anyway, yung transferee, kung gusto na niya matransfer sa pangalan niya yung shares of stock, anong gagawin niya? Fill lang niya yung blank. Fill in the blanks and he must insert his own name as the transferee and he will deliver the certificate to the corporation. The secretary of the corporation will enter the transfer in the stock and transfer book. So, yung certificate once surrendered, it is cancelled and new ones will be issued to the name of the transferee. So, obviously, this procedure cannot be followed kung wala pang nai-issue na certificate of stock. So, paano ang transfer niyan? Kung wala pang certificate of stock, it may be made in a separate instrument. So, ito na yung mga pumapasok na deed of sale, deed of conveyance, deed of assignment. This is done in lieu of endorsement of the certificate of stock. Pwede naman ito unless there is an express provision in the bylaws that transfer must be made exclusively in the manner authorized by the statute. So anyway, execution of yung separate instrument na to is equivalent to endorsement of the certificate. So, what else? Also, transfer may be made in case of dead stockholder. There is judicial or extrajudicial partition of his estate that will be necessary to transfer the shares of stock in favor of his heirs. So, validity of stock transfer. So, again, as between the parties, basta delivery lang ng endorsed certificate by the stockholder or his attorney in fact or person legally authorized to make the transfer. Now, remember, registration, hindi kailangan ng transfer yan to acquire the rights only against the seller/stockholder. Now, it is valid, unregistered transfers are not valid except as between the parties. So obviously, as between stockholder, yung original stockholder, and the buyer of the stocks, it is a valid conveyance. Yan. So, inference is that as between parties, it is valid conveyance. So, remember, it is the conveyance of the shares, not the registration, which will give the transferee title. What else? Also, please remember that the parties may also agree that the shares of stock would be registered in the name of the seller until the price has been fully paid. So, pagkabayad ng purchase price sa seller, dun palang i-register sa pangalan ng buyer. Such agreement is valid but only as between the parties. So, when the stock transfer is entered in the corporate books, buyer or the transferee will become a stockholder, enjoying all the rights of a stockholder. So, number 2 rule, please take note that in order to be valid against third persons and the corporation, the transfer should be entered and noted upon the books of the corporation. So, it will show the names of the parties to the transaction date of transfer, number of certificate, and also the number of shares transferred. Remember also, only absolute transfers need to be registered. So, yung mga mortgages, pledges, no need to actually register it. So, pero kung ni-register nyo, wala namang problema yon. So, ang kailangan lang talaga na i-register is yung complete alienation or absolute alienation or sale of shares. Yan. What else? Effects of unregistered transfer of shares. So, remember, valid and binding, katulad ng sinabi ko kanina, between transferor, stockholder, or record owner, and the transferee or beneficial owner. Valid or ineffective to the corporation, except when there is already notice given to the corporation for purposes of registration. Ito yung sinasabi ko kanina, corporation is already aware that there is a transfer. So, notice given to the corporation of the sale of the shares, presentation of the certificates for transfer, equivalent already to registration. So, the transferor has a right to vote and be voted for. Kasi nga, nasa kanya pa yung pangalan sa mga shares. What else? Number 2, transferor has the right to dividends as against the corporation because remember, yung transferor is still the nominal owner of the shares. Siya pa rin ang nakapangalan, nominal nga eh. But the trustee is, and also remember, yung transferor is the trustee for the benefit of the real owner who is the buyer already. Because remember, as between buyer and stockholder, the transfer is valid. So, ngayon, kung gusto mong ma-recognize as a stockholder, ikaw ang buyer ng shares of stock, you have to secure that standing by having the transfer recorded in the stock and transfer book. So, hanggat hindi mo na-register yan, yung stockholder is an outsider to the corporation. So, what else? Invalid against corporate creditors. So, transferor is still liable to the corporation kasi nga nasa kanya pa rin yung pangalan ng shares of stock. So, pero siyang unpaid subscription, even if binenta na niya yung shares of stock na yan, kailangan bayaran pa rin niya yan sa corporation. So, and also, in case yung corporation does not want to collect from him, creditors can also collect from the stockholder as long as the creditors already exhausted all the remedies against the corporation. What else? Invalid also as to attaching or executing creditors of the transferor, as also as well as subsequent purchasers in good faith without notice of the transfer, and indeed as to all other persons interested except the parties to such transfer. So again, it is invalid as to third persons but valid as to stockholder and transferee. So also please take note if unpaid stocks, unpaid yung stocks, it is non-transferable because pwedeng ilimit ito katulad nga ng nasabi ko kanina. So shares of stock against which the corporation holds any unpaid claim shall not be transferable in the books of the corporation. What else? Effect of over-issuance of shares. So, Yung over-issued shares, ibig sabihin, ito ay shares issued, at ano ba, ang authorized capital stock niya is 100,000 divided into 100 shares. So, ang pwede mo lang i-issue is yung 100 shares. Now, if you issue more than 100 shares, there is already over-issuance of shares. So, this is in excess of the maximum number authorized in the Articles of Incorporation. So, remember, these shares do not exist. And remember, class, rule is that over-issued stock is absolutely void. So, yun ang kailangan yung tandaan. Remember, even if the holder of the certificate is in good faith, he does not become a stockholder. So, what else? Action may be maintained by the corporation to cancel over-issued shares, but the corporation may be held liable for damages or for restitution for an innocent purchaser for value. Yung naniwala siya na siya ay isang stockholder, so nagbayad siya, in good faith siya. So, yung corporation may be liable for damages as to him. What else? Please take note also of issuance of stock certificates. Sinabi ko na rin kanina to in passing. So, issuance of certificate of stock is only upon full payment of the subscription together with interest and expenses in case the shares are delinquent or if any is due. So, please take note also that pagka merong in-issue na no par value shares, obviously, walang balance yan because they are always issued as fully paid. Now, ang nagkakabalance lang talaga is yung mga par value shares. Anyway, ang binayad nyo sa par value shares is always deemed prorated. So, kung halimbawa meron kayong 100 shares at par value of 10 pesos per share, the total subscription is 1,000. So, you made an initial payment of 500. So, remember, yung 500 mo is not full payment for 50 shares. But, ang mangyayari dyan, yung 500 mo is payment pro rata for the entire 100 shares. So, each share is paid 5 pesos. And in which case, no certificate of stock will be issued until the same is fully paid. So, yun ang tandaan natin. Ang binayad mo sa 500 is 5 pesos per share. Note also, class, the liability of stockholders on unpaid subscription to corporate creditors. Usually, ang unpaid subscription ng stockholder is a liability as against the corporation. Now, also, please take note na yung mga third persons or creditors dealing with the corporation, they must be aware na ang pwede lang nilang habulin is corporate assets, but they cannot run after the stockholders dahil nga sa doctrine of corporate entity. Now, this exception, remember, will depend only if there is full payment of the subscription contract. Now, please take note also that the subscribers na may mga balance sa kanilang subscription, again, uulitin ko, this applies only to par value shares. Kasi pagka no par, issued as fully paid and non-assessable. Bayad na kasi yan. Itong par value, pwedeng may utang ka. So, with respect to the balance, debtor yung stockholder to the corporation. And if the corporation does not collect from the debtor/subscriber, creditors may do so. So, pwedeng yung mga creditors na ang mag-collect mismo from the subscribers who have unpaid obligations to the corporation. So, what else? Rights of stockholders in general. So, as a general rule, class, stockholders are given certain rights by the corporation law so that they can protect themselves from possibility of misuse of corporate funds and mismanagement by those who are directly involved in the corporate affairs. So, there are three categories of rights of stockholders. So, management rights. So, anong mga klase ng management rights? Right to attend and vote in person or by proxy at the stockholders meeting. Right to elect and remove directors. Right to approve certain corporate acts. What else? Right to adopt and amend or repeal the bylaws or adopt new bylaws. Right to compel the calling of meetings of stockholders when for any cause there is no person authorized to call a meeting. Right to enter into a VTA. Right to voluntarily dissolve the corporation. Yung namang mga proprietary rights are right to transfer of stock on corporate books, right to receive dividends when they are declared, right to issuance of certificate of stock, right to participate in the distribution of assets upon dissolution, and preemptive right. Remedial rights naman, right to inspect corporate books and records, right to recover stocks unlawfully sold for delinquency, right to be furnished most recent financial statements upon request, and also receive financial reports of the corporation's operation, a right to bring individual or representative or derivative actions against the corporation. What else? Right to demand payment of the value of his shares and withdraw from the corporation in the exercise of the appraisal right in certain cases. So, yun ang mga remedial rights. So, anyway, all of them are in your book. Check nyo na lang. Di naman ako nag-recommend ng book para sa wala lang. So, anyway, you can go over this video again and again since it's already posted publicly. Hindi na restricted ang mga videos. You know why, class? Because in section B, they already told me that they already found a way to pirate my videos. So, wala nang sense na i-restrict because mamaya i-upload pa nila somewhere. So, ako na lang, nagkusa na lang ako. The only disappointment I have is that ngayon nyo lang na-figure out. So, mahigit kalahati na ng SEM. Ngayon nyo lang na-figure out kung paano mag-pirate ng restricted videos. So, obviously, dahil buti na lang nilagay ko yung mukha ko dito, hindi nyo pwedeng i-claim na sa inyo. So, ang galing talaga ni Valerie. Siyang favorite student ko of all time. Also, class, please take note of actions by stockholders or members. So, if the wrong or injury is done directly against the corporation, remember that it will give rise to a cause of action on the part of the corporation alone based on the doctrine of corporate entity. The personality of the corporation is separate and distinct from that of the corporators comprising it. Also, in case of lack of cause of action on the part of officials of the corporation, this talks about derivative actions. So, derivative actions are in the nature of a representative suit. They are remedies in equity. So, it is defined as one brought by one or more stockholders or members in the name or on behalf of the corporation to redress wrongs committed against it, to protect or vindicate corporate rights whenever the officials of the corporation refuse to sue or are the ones to be sued or hold control of the corporation. So here, may abuses na nangyayari in terms of management. And also, mayroong probable neglect, etc. or wrongs. But yung mga dapat na mag-vindicate ng corporate rights, they refuse to sue also. So, anong gagawin ng mga stockholders? Ayaw magdemanda ng mga directors. Tapos, ayaw nilang i-vindicate yung right ng corporation. So, it can happen na itong mga directors na to or trustees, sila pa mismo yung kailangang idemanda. Why? Because there is fraud in the management, there is neglect, etc., etc. Anong gagawin nila? The stockholders will file a derivative suit or derivative action. Now, the suing stockholder will be regarded as the nominal party. Ibig sabihin siya yung nakapangalan sa action. But the corporation is the real party in interest. So, in a derivative suit, what you have to remember is that it is, sabi ko nga kanina, in the nature of a representative action, and the stockholder will bring the action in the name and in behalf of the corporation for a wrong done to the corporation. So remember, this is to redress corporate rights. So, ang binibindicate dito, corporate rights, not the wrong done to the individual stockholder himself. So, ang stockholder dito is only a representative of the corporation. It is a derivative suit because, remember, yung right to file this is derived from the corporation. Kaya nga, derivative, derived. So, any recovery will belong to the corporation and not to the stockholders or individually. But obviously, the petitioning stockholder or yung nag-file will be entitled to reimbursement of legal expenses. Now, yung individual suit naman is when the wrong is directly inflicted against a stockholder. So, yung stockholder na yan, pwede siya mag-file ng individual or direct suit, and this time, it is in his own name, and the cause of action is available to him. So, here, there is a violation of the contractual rights or other rights of the stockholder, idedemanda niya yung corporation. What else? Class suit or representative action. Remember, the wrong here is committed against a group of stockholder. One of them or a representative of the group of stockholders may bring a suit in behalf of himself and all other stockholders who are similarly situated. So, class action yan. So, mas matipid daw ang mga class action kasi isa lang ang mag-file, i-represent niya lahat. What else? Please take note also of the liabilities of stockholders. Liability for unpaid subscription, interest on unpaid subscription, liable to creditors of the corporation on unpaid subscription, but again, subject to exhaustion of remedies against the corporation. So the creditors must exhaust first remedies against the corporation before they can proceed against the stockholders on their unpaid subscription. Liability for watered stock, liability for dividends unlawfully paid, and also liability for failure to create a corporation. How about watered stocks? So watered stocks are stocks issued as fully paid but not in exchange for its equivalent either in cash, property, shares, stock dividends, or services. So here, class, ang binayad sa shares o stock, walang bayad or may binayad pero kulang. But remember, para maging watered ang stock, it must be issued as fully paid. So, probably meron ng certificate of stock dito kasi nag-i-issue lang naman ng certificate pagka fully paid na yung subscription. Anyway, the kinds of watered stock are bonus, walang consideration, bigla na lang meron, and issued as fully paid. What else? Discount shares. So, issued as fully paid when the corporation has received a lesser sum of money than its par or issued value. What else? Also, stock issued for property valued at less than par or issued value. So, property or ang pinambayad dito, pero yung property is less than the subscription. So, kung ang subscription is 1 million, the property, kung yung valuation ng property is, let us say, 800,000 lamang. Ganon. So, what else? Stock dividends issued without surplus profit. So, stock dividend, dapat di ba meron tayong unrestricted retained earnings before you issue stock dividends. Here, walang unrestricted retained earnings yan or surplus to justify yung issuance ng stock dividends. What else? Obviously, issuance of watered stocks is prohibited. Bakit? To protect persons who may acquire stocks and the creditors of the corporation, particularly those who may become such on the fate of the outstanding capital stock being fully paid. So, all of the creditors, they think that the outstanding capital stock is fully paid. Yung pala, yung mga binayad ay kulang. Property valued at less than the subscription, etc. etc. So, ayun ang kailangan yung tandaan sa watered stock. So, anyway, the prohibition here refers to original issues of shares. So, kung halimbawa, ang transfer is from stockholder to stockholder, na ang par value niya is 50 pesos, tapos one stockholder transfers it to another stockholder for less than par value, or let us say 25 pesos na lang. water stock ba yun? Hindi. Kasi this is different now. It is in the nature of a contract of sale. Hindi na ito yung technically subscription contract with the corporation. Ang kailangan lang naman talagang makareceive ng more, at least a par or more than par or more than issued value is yung corporation. So, subsequent transfer is no longer considered an issue but a sale of stocks. Yan. So, pagka treasury shares also may be sold at less than par or issued provided that the price is reasonable. Yan. So, what else? What is the effect of issuance of watered stocks? So, issuance of watered stocks is not merely ultra vires but it is illegal per se and also a violation of the trust fund doctrine. So, ilang beses nating pinag-aralan yung trust fund doctrine. Dapat alam nyo na yan ngayon. What else? As to creditors, there is no distinction between those who became such prior and subsequent to the issuance of watered stock. There is liability whether or not the creditors have relied on an overvaluation of the corporate capital. As to SEC naman, whether or not the issuance would amount to an issue of watered stock is within the authority of the SEC to inquire into. So, jurisdiction ng SEC yan if there are disputes regarding watered stocks. What else? Liability for watered stocks. Remember, this is director of a corporation who consents to the issuance of watered stocks. Consents to issuance of stocks for a consideration other than cash and property ganyan valued in excess of its fair value or having knowledge of the insufficient consideration does not file a written objection with the corporate secretary. And remember here also that liability is solidary with the stockholders concerned for the difference between the value received and the at the time of issuance of the stock and the subscription. So, yun ang tandaan natin. So, liability for the water is, again, solidary with the participating stockholder. So, ang valuation is based on the time it is paid to the corporation. So, if I pay with property, again, example ko kanina, my subscription is 1 million. I paid with property valued at yung valuation niya is, let us say, 800,000. Nag-issue sa akin ng shares of stock pursuant to the subscription amount of 1 million. And nung in-issue sa akin yung certificate of stock, it is issued as fully paid. Pero yung value ng property na binayad ko is kulang. So here, there is water in the stock. So ang amount ng water is 200,000 pesos. So for the water in the stock, all of the participating stockholders are liable solidarily. Kung sino ang nag-consent dyan, obviously, I am liable. And also yung mga directors who consent to the issuance of the certificate of stock as fully paid when yung valuation ng property ko is less than par value or less than the subscription. Also, please take note that the subsequent ano bang tawag doon, yung increase in the value of the property. Let us say nagkaroon ng increase in the value of the property. It is appraised at 1.2 na. Remember, watered pa rin yung stocks because the reckoning point is at the time of payment doon sa shares. So, at the time the contract, subscription contract is entered into, yung value niya is 800. If there is an increase in the value of the property, watered pa rin yan. Kasi nung time na ibinayad, less than the subscription amount. Now, in case there is subsequent devaluation naman or decrease in the value of the property, hindi ito watered stock. Halimbawa, 1 million yung property ko, yun ang value niya, 1 million ang subscription ko. Later on, my property, nag-decrease siya ng value into 800,000. Hindi watered yung stocks na na-issue sa akin. Kasi again, ang reckoning point is at the time of the subscription contract, at the time I paid for the shares. So, yun ang kailangan yung tandaan sa watered stocks. What else? Interest on unpaid subscriptions. Under Section 65, kung merong nakalagay sa subscription contract na mayroong interest, obviously, the stockholder is liable for interest. Now, even if not so required by the subscription contract, of course, pagka delinquent na yung shares, liable na to pay interest from the date of delinquency. Yan. What else? Rate of interest, legal rate. So, what is the legal rate of interest? Naku, nakalimutan nyo na naman, I'm sure. 6% per annum. Bangko Sentral Circular Number 799, Series of 2013, enacted June 21, 2013, 6% per annum again. Tandaan nyo. So, kung may rate na sa subscription contract, yun ang kasunod. Pero, yun ang masusunod. But if there is no rate in the subscription contract, we will follow the legal rate of interest. Obviously, interest may be waived by the corporation if it desires. Now, these are the remedies to enforce payment of stock subscription. Ano ba yung mga remedies? So, tatlo yan. Extrajudicial sale at public auction. So, first and most special remedy. Yan. So, there will be an auction of the shares of stock belonging to a delinquent stockholder. Yan. What else? Judicial action. Remedy is provided for by the court under Section 69, and ito rin, collection from cash dividends and withholding of stock dividends. Please take note also of the punishment provided by law due to stock delinquency. So, the stockholder is denied his rights. Anong mga rights ang denied sa stockholders whose shares, whose subscription is delinquent? They are not entitled to be voted for, or they are not entitled to vote or representation at any stockholders meeting, or any of the stockholders' right except the right to dividends. And remember, in Section 23, it's also expressly provided that no delinquent stock shall be voted. Now also, please take note that meron tayong dividend right kung ang ating subscription ay delinquent. Pero, under Section 42, the corporation has the right to first apply cash dividends due on delinquent stock to the unpaid balance. So, imbis na makukuha mo yung dividends, it will be applied first to the unpaid balance plus cost and plus expenses. And also, in case of stock dividends, pagka yun ang nakadeclare, it is withheld from the delinquent stockholder until he pays his subscription in full. Right is may be exercised by the corporation even though it is not provided for in the bylaws. Kasi sabi nga sa law, specifically Section 42. Now, payment of unpaid subscription or a percentage thereof, kailan dapat gawin yan? If there is a date specified in the subscription contract, dun mo kailangang bayaran yung balance ng iyong subscription. So, yung unpaid portion niya, or kung halimbawa, yung balance mo is payable in several dates, syempre, yung percentage due on a particular date, you have to pay it based on the dates specified in the contract of subscription. Now, kung halimbawa sa contract of subscription, November 6, kailangan mo magbayad sa November 6 kasi yun ang due date mo. Now, paano kung wala sa subscription contract ng date within which you have to pay for the balance of your subscription? So, in the absence of any specified date, kailangan magkaroon ng call made by the board of directors. So, a call is a resolution of the board of directors. Tapos, it will order payment noong unpaid portion ng subscription ng isang stockholder. Again, this will apply to par value shares only na pwede kang mag-iwan ng balance. So, mag-i-issue ang board ng resolution, tapos let us say in the call, ang tawag doon sa resolution na yun na nagsiset ng due date para sa payment ng unpaid subscription ay call. So, nasa call, kailangan nyo magbayad ng November 6. You have to pay on November 6 because that is the date stated in the call. Now, remember, class, na kung merong date sa contract of subscription, yun ang magpe-prevail even if mag-call ang board ng another date. kung ano yung nakalagay sa contract of subscription. That is the law between the parties. Now, what if you fail to pay on the date provided for in the contract of subscription or in the call made by the board of directors? The effect is that the entire balance due and payable, the entire balance will become due and payable and will make the entire subscription delinquent, and it may be sold at public auction. So let us say, class, bumili ka ng 5 shares of stock at 100 pesos each share. So yun ang par value niya. So ang total subscription mo is 500 pesos. That is the amount of your subscription. Let us say ang paid up mo dun sa 500 na subscription mo is 300 lamang. So may balance ka na 200 pesos. So you have to pay that on the date of on the date stated in the contract of subscription, or if there's no date, on the date stated doon sa call na i-issue ng board of directors. Now, if you fail to pay, remember, ang magiging delinquent dyan is hindi yung 2 shares na parang that appears na hindi mo nabayaran kasi di ba ang binayad mo is 300. But again, remember the rule that I've said before. Yung payment mo is applied pro rata to all of the shares na ibinayad mo. So, in short, wala kang nabayaran ng buo. So, portion lang ang binayad mo sa bawat isang share. So, ang kailangan yung tandaan dyan that your entire subscription will become delinquent. So, yung 5 shares na binili mo, delinquent lahat yan. Because, according also to this, the subscription is one entire indivisible whole contract. So also, stockholder will be liable for interest at the legal rate on such balance unless there is a different interest rate provided in the bylaws or also in the subscription contract computed from such date until full payment of the balance on the subscription. Effect of payment, obviously, your shares are no longer delinquent. You will be restored to all of the rights of the stockholder. And syempre, kung nabayaran mo na yan, tapos full payment, pwede ka na rin issuehan ng certificate of stock. But also, remember, you have to pay yung balance with interest, costs, and other expenses. When does a stock become delinquent? Obviously, if you fail to pay the balance thereof 30 days from the date specified in the contract of subscription, or in the absence of a date fixed in the contract from the date stated in the call made by the board of directors. Please take note of the definition of call. Declaration officially made by the corporation, usually expressed in the form of a resolution of the board of directors, which will require payment of all or certain prescribed portion of a subscriber's stock subscription. So, the board of directors has the power to make a call. So, this is not an absolute power. Katulad nga ng sinabi ko kanina, it is limited by the subscription contract. So, the directors cannot disregard the amount to be paid as provided for in the subscription contract, and also the date kung kailan babayaran yon. So, even if there is a call, yung ordering payment earlier, masusunod pa rin yung nasa subscription contract. The requisites for a valid call are, number 1, it must be made in the manner prescribed by law. Number 2, it must be made by the board of directors. Remember, in case of call, it is not subject to approval of the stockholders also. And lastly, it must operate uniformly upon all shareholders. So, what else? Please take note also of the procedure for the sale of delinquent stocks or delinquency sale under Section 66 and 67. So, ang unang gagawin ng Board of Directors is to issue a resolution declaring unpaid subscriptions payable. So, in short, they will issue a call. But remember again, yung call, magkakaroon lang yan if there is no date fixed in the subscription contract. If there is a date fixed in the subscription contract, a call is not necessary. So again, let us say November 6 is the date fixed in the contract. So yun ang due date kung kailan dapat bayaran yung balance ng subscription. Now, kung wala yung date na yun in the subscription contract, the board of directors must issue a resolution na nagsiset ng date for payment of unpaid subscription. So let us say again, sa call ang ginawa nila is November 6. So kailangan dun ka magbayad ng iyong balance ng subscription. What else? Number 2, there must be a notice to the stockholders of the call made. So, magko-call ka nga. Ito ang araw ng bayaran, pero hindi alam ng stockholders mo. So, obviously, there is something wrong there. So, you must notify yung stockholders of the call. So, notify them. Kaya, notice of call nga. So, given notice, stockholders will be given notice of the resolution by the secretary of the corporation, personally or by registered mail. And remember that if the stockholders do not pay within 30 days from the date specified in the contract or in the call, all stocks covered by the subscription shall thereupon become delinquent and subject to public sale. So, obviously, unpaid shares which are not delinquent pa are not subject to sale. Tapos, the delinquent status of unpaid subscription may be removed, obviously, when there is payment ng balance. Now, let us say, November 6 ang date sa call or November 6 ang due date sa subscription contract. So, nagkaroon ng, in case na walang call, ay walang date sa subscription contract, ang nakalagay sa call is November 6, no? The stockholders will be notified of the date ng due date. So, binibigyan sila ng notice of call. So, let us say again, basta, in both cases, the due date is November 6, 2020. So, remember, bibigyan ng grace period ang stockholder within which to pay. So, kailangan magbayad siya within 30 days from the date specified in the contract. So, kung November 6 yun, you count 30 days, you have to pay hanggang December 6, 2020, if my computation serves me right. Now, pagka hindi ka nakabayad within yung 30 days, on the next day, your shares will become delinquent. So, as of December 7, 2020, the shares are already delinquent. Now, obviously, pagka nagkaroon na ng delinquent shares, lahat ng rights ng stockholder nawawala na except the right to receive dividends. Now, yung mga directors will also issue a resolution ordering the sale of delinquent stocks. So, yung resolution will state the amount due, the date, time, and place of the sale with notice to the delinquent stockholders. And remember, yung notice of sale will be published. Yung notice of call, you do not need to publish. But the notice of sale, para nga naman may magbid sa auction ninyo. So, you have to have it published. So, obviously, the board of directors will determine the selling price of the delinquent stocks. So, anyway, that date, time, and place of the sale shall not be less than 30 days, nor more than 60 days from the date the stocks become delinquent. And this will be set in the resolution as well as in the notice of sale. Now, if I go back to our example, the shares, they became delinquent December 7, 2020. So, pagka-delinquent nila, nagkaroon ng board resolution that they are ordered to be sold at public auction. And obviously, yung date, time, and place of the sale will be published, or yung notice of sale, yung mga information regarding the sale. So, yung notice of sale will be published, and yung notice of sale will contain yung date kung kailan gaganapin yung auction. So, the auction shall not be set less than 30 days nor more than 60 days from the date the stocks become delinquent. So the stocks, they became delinquent in our example December 7, 2020. So kailangan mag-set ako ng sale sometime in between, if I'm not mistaken, class, alam niyo naman, mere lawyer, not accountant, sometime January 7, that is not less than 30 days, so 31st day is January 7, 2020, and the 60th day is February 5, 2020. So, between yung dates na yon, pwedeng January 7 hanggang February 5, 2020 ko iset yung auction sale. Now, let us say, class, sinet ko siya ng, just example lang, January 20, 2021. Yan ang aking sinet na date ng sale. So, anyway, obviously, yung notice of sale, katulad nga ng sinabi ko kanina, will be published. Yan. Notice of the sale and copy of the resolution shall be sent to every delinquent stockholder, either personally by registered mail or through the other means provided in the bylaws, and published once a week for 2 consecutive weeks in a newspaper of general circulation in the province or city where the principal office of the corporation is located. Obviously, pagka dumating yung date na nakalagay sa notice of sale at saka nakalagay sa resolution, doon na mangyayari yung sale ng delinquent stock. So many shares of stock as may be necessary to pay the amount due on the subscription with accrued interest, cost of advertisement, and expenses of sale will be sold at public auction to the highest bidder for cash. So, highest bidder is a person who will offer to pay the full amount of the balance on the subscription together with accrued interest, cost of advertisement, and expenses of sale for the smallest number of shares or fraction of a share. So, let us say, class, meron tayong tatlong bidder. Remember my example a while ago, 5 shares at 100 par value. So, ang kanyang total subscription is 500 pesos. Paid only 300. Balance is 200. Naging delinquent ang shares. Failed to pay on the date stated in the call, or failed to pay on the date stated in the subscription contract. Grace period, failed pa rin. So, the shares became delinquent. Now, ang delinquent class is yung 5 shares. Again, 5. Yung entire subscription becomes delinquent. Now, magpapabid tayo. May 3 nagbid. Si A, nagbid siya. Before that also, for the auction sale, nagkaroon ng interest. Let us say interest is 50 pesos. Nagkaroon din ng costs for advertisement, expenses of sale. Sabihin na, itotal na nating lahat. Package deal. 75 pesos. Ang laki, no? So, anyway, ang ating mga bidders ay A. Nagbid siya ng 200 for 1 share. Yan. Si B naman, nagbid siya ng 275 for 4 shares. Si C naman, nagbid siya ng 250 for 3 shares. And si D, dagdagan natin, syempre. Alam niyo naman. Basta, dagdagan natin. Si D, nagbid siya ng 275 for 5 shares. Now, again, uulitin ko, pero medyo nakalimutan ko na. A, 200 for 1 share. B, 275 for 4 shares. C, 250 for 3 shares. And D, 275 for 5 shares. Who is the highest bidder? Is it A? Not A. And also not C. Why? Because A offers to pay 200 pesos only. Only the balance of the subscription. Ayaw niyang bayaran yung interest, cost of advertisement, and expenses. Kailangan bayaran din yon. That is a precise reason why C is also out, because C offers to pay 250 only. Kulang. Now, ang naglalaban na lang talaga is B and D. B offers to pay $275 for 4 shares. D offers to pay $275 for 5 shares. Remember here that the highest bidder is B. Bakit si B? Because B offers to pay the balance plus cost of advertisement, interest, and expenses of sale for the smallest number of shares. Kasi mas konti yung gusto niyang kunin. 4 lang ang gusto niyang kunin. Etong si D, gusto niyang kunin lahat ng shares. So, B will be considered as the highest bidder. So, yun ang kailangan yung tandaan. B is the highest bidder. Now, anong mangyayari ngayon if D is the highest bidder? So, yung buong subscription will be deemed fully paid. Tapos, si B, dun sa example natin who is the highest bidder, will be issued a certificate of stock for 4 shares. Now, yun namang isang share na hindi niya kinuha will remain in the name of the stockholder na delinquent. So, yun ang kailangan nating tandaan. The stockholder who is delinquent will retain 1 share. But anyway, here, dahil nga nagkaroon na ng full payment because of the auction, si delinquent stockholder is no longer delinquent actually. Yan. Tapos naman, kung remember, if it happened that D is the highest bidder, all 5 shares of the delinquent stockholder will be forfeited. Yan. So, swerte mo na lang kung hindi kinuha lahat ng shares mo. Purchase by the corporation of delinquent stock, pwede naman yan as long as there are unrestricted retained earnings in view of the trust fund doctrine. This is a power granted to the corporation to purchase its own shares. We have already discussed this in Title 4. What else in relation to that? Section 68, the grounds to recover stock unlawfully sold for delinquency. If pwedeng i-recover yung shares ng delinquent stockholder because there is an irregularity or defect in the notice of sale, baka hindi na-publish, etc., etc. There's an irregularity or defect. What else? Irregularity or defect in the sale itself of the delinquent stock. So here in this case, remember, delinquent stockholder can recover yung shares niya unlawfully sold. What else? Judicial remedy to recover unpaid subscription. Section 69, if I'm not mistaken, di ko na ilagay. Corporation may not maintain suit for enforcement of unpaid subscription without first making a call. Call muna. Or at least there is a date in the subscription contract bago siya makapag-demanda. So, the judicial remedy, remember, is limited only on the amount due on the unpaid subscription plus interest, costs, and expenses. So, hindi siya pwedeng magkaroon ng ibang claim against the delinquent stockholder. So, bawal ang damages in short. And remember, the judicial action to recover unpaid subscription based on a written subscription contract is 10 years from the time the right of action accrues, or within 6 years if based on a verbal subscription contract. So, yung prescriptive period na 10 years or 6 years as the case may be will begin from the date demand is made of the subscriber by the corporation to pay the balance of the subscription. Now, the effect of delinquency under Section 70, it will deprive the stockholder of the right to vote and be voted for and other rights except the right to receive dividends. But remember, this is subject to Section 42. Cash dividend apply first to the balance and yung stock dividends will be withheld. Tapos yung delinquent stocks will be subject to delinquency sale, as already discussed. Pagka naman nagkaroon ng full payment, ng delinquent shares, he will be restored to all the rights of a stockholder, and dahil full payment nga, pwede na siyang ma-issue ng certificate of stock. Rights of unpaid shares, remember, they have all the rights. Bakit? Kasi unpaid pa lang naman, hindi naman siya delinquent shares. Mabilis naman nun. Hindi siya delinquent shares. So, such right will begin from the time his subscription is accepted by the corporation, or if the offer is made by the corporation, from the time the offer is accepted by the subscriber. Yan. What else? Lost, destroyed, or stolen certificates of stock. So, nawala ang yung certificate of stock, nanakaw, or nasira. So, what is the procedure? Number 1, registered owner must file an affidavit in triplicate with the corporation. So, 3 copies. Yan. Anong laman ng affidavit? Circumstances as to how the certificate was lost, stolen, or destroyed. Nung minsan naglalakad ako sa Mount Makiling, nilagay ko siya sa backpack ko, tapos yung backpack ko nalaglag sa Kumunoy, tapos naglaho yung backpack ko, tapos nandun sa loob yung certificate of stock, etc., etc. So, that is yung circumstances how the certificate was lost. Tapos, kung halimbawa stolen, naglalakad ako sa skyway, tapos bigla may huminto na sasakyan, hinold up ako, etc., etc. Destroyed naman, yun nga, yung nasira din ng Kumunoy siguro, or natamaan ng lava, or natamaan ng asteroid, etc., etc. So, you must indicate paano nawala yung certificate of stock mo. Number of shares represented by the certificate, serial number, name of the corporation which issued the same. So, the corporation will verify the affidavit. Tapos, pagka na-verify na niya, there is publication of a notice once a week for 3 consecutive weeks in newspaper. Nakakapagod, ang daming words sa corporation law. Anyway, newspaper of general circulation in the place where the corporation has its principal office. And ang magbabayad ay ng publication ay yung stockholder. Yan. Yung may-ari ng certificate of stock. Contents of the notice na ipapublish, name ng corporation, name of registered owner, serial number, number of shares represented by the certificate of stock. What else? 1 year bago sila mag-issue ng certificate of stock. 1 year after, parang hindi ko na ilagay ito. Anyway, after 1 year from the date of the last publication, the corporation shall cancel in its books the certificate of stock which have been lost, stolen, or destroyed, and issue new certificates of stock. So, wait pa ng 1 year yung stockholder from the date of the last publication. Now, if you want the certificates of stock to be issued earlier, the registered owner or the owner of the certificate of stock must file a bond or other security effective for 1 year and for a sum and in such form and with such securities as may be satisfactory to the board of directors. What else? Contest has been presented. Ibig sabihin, there's a controversy, may demanda, etc., etc. May nag-aaway tungkol sa ownership ng certificates na yan. Action is pending in court. So, hindi pwedeng mag-issue ng new certificates of stock. It will be suspended until the final decision by the court regarding the ownership noong shares of stocks, certificates of stocks which are allegedly lost, stolen, or destroyed. So anyway, that's it for Title 7 of the Revised Corporation Code of the Philippines. Anyway, class, have a good day. Thank you.